Before a federal court will certify a case as a class action under Rule 23A of the Federal Rules of Civil Procedure, or FRCP, the representatives of the class must prove they meet certain requirements. But what if only one representative has standing to bring the suit? A federal district court in New York considered this question in Floyd v. City of New York. Between 2004 and 2009, the New York City Police Department, or NYPD, engaged in over 2.8 million Terry stops, which are brief investigatory seizures by law enforcement that fall short of a traditional arrest. Over 50% of the people stopped were Black, and 30% were Latinos. Further, at least 60,000 of the stops were illegal in that they weren't based on reasonable suspicion. David Floyd, Lalit Clarkson, Dion Dennis, and David Auerlich were 4 Black men who were subjected to Terry stops in New York City on at least one occasion without reasonable suspicion. In fact, Auerlich, a New York City resident, had been stopped 4 times, including when he was walking along a sidewalk, sitting on a bench, and entering a car. In 2008, the group brought a class action against New York City and others in the United States District Court for the Southern District of New York. They alleged that the defendants failed to reform their policies and practices based on the settlement reached in a previous case. Further, the group sought 2 things. First, a declaration that the NYPD's policies and practices fostered unlawful, racially discriminatory searches and seizures in violation of the class's 4th and 14th Amendment rights. And second, a class-wide injunction requiring the police to change its policies and practices. Following discovery, the group moved for class certification.